answering a complaint. When you are answering a complaint, it is very much like any other filing. What you're going to do is file a piece of paper and mail or serve or fax or email to the other side or to all other parties exactly what your response, what your answer is to that complaint. Those answers are usually in the form of one of three responses. The first, admit. I admit the allegation. I'm saying it's true. Denied. I am denying the allegation because I am saying it is not true. You can actually admit in part and deny in part if you believe that part of the allegation is true, but the rest of the allegation is not. So you can say, I admit that we are in the business of selling footballs, but we deny that that's all that we sell. That third category, besides admit or deny, is what happens if I don't have knowledge? Well, I don't know whether I can admit or deny. I don't want to say denied summarily because it might be true. So if I don't have knowledge, it's not reasonable for me to have that knowledge. I can put that third category of without knowledge and therefore denied. So I have admit, I have deny, and maybe some combination, and then I have without knowledge and therefore deny. The way I actually send that is to write on a piece of paper with that caption that we spoke about. That top part that has the names of the plaintiff versus the name of the defendant, the name of the court, and then it has the case number. And then I title all of my papers I file with the court, answer. Or as I'm about to talk about, answer and affirmative defenses. And I say, the defendant comes now, or the defendant files its answer and says. And then you take the numbered allegations. Let's say they have 25 numbered allegations, and you number 1 to 25, and you're either going to have admit, deny, admit in part and deny in part, or without knowledge and therefore denied on each one of those numbers. You want to separately respond to each one. I mentioned affirmative defenses. Sometimes you will actually have an answer and affirmative defense. And those answer and affirmative defenses may be contained in the same document. There are jurisdictions which allow you to file them separately, but most jurisdictions require you to file any affirmative defenses with an answer. What are affirmative defenses? They are defenses which are affirmatively made that say, even if you're right, I still win. For example, let's suppose that I am claiming that somebody didn't pay me for goods that were delivered. And I am suing for breach of contract. And let's say that you say, even though you may think you're right, I actually already paid you. That would be an affirmative defense. They sometimes call that accord and satisfaction. Legal terms for I have satisfied my obligation. So that is not an admission or denial. It is saying, regardless of what you're saying, I still win because I actually paid you for those footballs. I actually paid you for those goods that you delivered, so you don't have a cause of action. So that isn't called an affirmative defense. And you actually number those the same way that you number your allegations and your denials, depending on what document. So if I go back to the complaint, I would number my allegations, each fact, each legal concept. My answer, I would number each of my denials to each of those paragraphs. My affirmative defenses, I would number each one. As my first affirmative defense, the defendant asserts the doctrine of accord and satisfaction. The evidence shows, as it here shown by the attached canceled check, that the payment was fully made and therefore no money is owed. So you can see what I'm doing. And each one of these documents, just like the complaint was filed with the clerk, so too do you take the answer and affirmative defense or motion or other response and file it with the court. Now, under the law, you not only must file with the court, you must provide every party with a copy. And the way you provide it, they call that serving it on a party. Filing, the word filing, means providing it to a court. Serving goes more to exactly who is getting those documents besides the court. Like I am serving it on the parties. Or if I had a subpoena or something on a witness, I'm serving it on a witness. And depending on whether you have a party or a non-party, there are different rules. So when I have a party, I serve it by mailing it, by emailing it, by faxing it. If it is a non-party, unless there's an agreement, I must subpoena that person for information. Why? I don't have jurisdiction over them. They are not subject to the court like parties are. That is why you have to file an official subpoena, which has to be served like a complaint by a duly authorized officer. Now, more jurisdictions are moving towards allowing a lawyer to actually have that document served by signing a subpoena themselves, himself or herself. But the concept is to understand that serving refers to the actual delivery, mailing, or transmission of the document to a party. That's the concept and the distinction between those documents. Just the same as you did in a complaint, you need to actually take that document and file it with the court. The court is the official holding tank of all of the documents that are related to the case. Now, there are exceptions, like in the federal court system, you don't necessarily deliver all of your discovery and photographs and documents that might be responsive. You don't actually file that with the court because they don't want to clutter up the court system with thousands of documents. They don't want that. So you might have a certificate saying that you produced those documents. And you would file that piece of paper, and then you just send the documents to the other side. But the concept is to understand that I can respond by either filing a motion or filing an answer and affirmative defenses if they are applicable, and I write them out in the same sort of format. That's a productive way to respond to a complaint.